Suffolk County DWI and DUI defense lawyer. A DWI arrest in Suffolk County can derail your freedom, career, and future. New York distinguishes between DWI, aggravated DWI, and driving while ability impaired based on your blood alcohol content in circumstances. A first DWI conviction requires a BAC of 0.08% or higher and can lead to up to a year in jail, $500 to $1,000 in fines, and at least 6 months without your license. Aggravated DWI applies when your BAC is 0.18% or a child under 16 is in your car and brings higher fines, longer revocation, and a mandatory ignition interlock. Driving while ability impaired covers a BAC between 0.05% and 0.07% and is a traffic infraction punishable by smaller fines and a 90-day suspension. Second and third convictions within 10 years are felonies that can result in multi-year prison sentences. Most DWI stops occur after erratic driving or at sobriety checkpoints. The officer will observe your appearance and may ask you to perform voluntary field sobriety tests, which are subjective. Preliminary breath tests are generally inadmissible, but after arrest you must submit to an official breathalyzer. Refusing the chemical test leads to an automatic license revocation of at least a year and a civil penalty, and prosecutors may argue that refusal shows intoxication. A DWI arrest triggers both a criminal case and a DMV proceeding. You must request a DMV refusal hearing within 15 days to prevent immediate revocation. At the hearing, your defense counsel can cross-examine the arresting officer, challenge the calibration of the breathalyzer, and argue that the stop lacked reasonable suspicion, potentially resulting in dismissal. Defenses also include questioning whether the machine was properly maintained and whether medical conditions like GERD or diabetes affected the results. Field sobriety tests can be unreliable because injuries, fatigue, uneven pavement, or weather may affect performance. A skilled defense counsel reviews police reports, video evidence, and calibration records to uncover weaknesses in the case. A conviction leaves a permanent record that may limit employment opportunities, trigger professional license suspensions, raise insurance costs, and restrict travel. New York allows sealing of some DWI convictions after 10 years, but the requirements are strict and not all cases qualify. In certain situations, prosecutors may agree to reduce charges to driving while ability impaired, which avoids a criminal record and carries smaller fines. Factors for reductions include low BAC, problems with the stop or breathalyzer, and a clean record. An experienced lawyer can advocate for a reduction to driving while ability impaired and help you minimize penalties. After an arrest, you should consult counsel promptly, request your hearing quickly, avoid statements beyond identifying yourself, document the stop, preserve receipts and witnesses, and stay off social media. New York's BAC limits are 0.08% for most drivers, 0.04% for commercial drivers, and 0.02% for those under 21. Convictions require installation of an ignition interlock device on any vehicle you own or operate. Suffolk County DWI attorney Jason Bassett is a former prosecutor with more than 20 years of criminal defense experience and membership in national defense organizations. He appears regularly in local courts and uses his prosecutorial insight to protect clients' rights and challenge weak evidence. His direct communication, thorough preparation, and advocacy have earned clients' trust. The law offices of Jason Bassett, PC, serves clients throughout Suffolk County and Long Island, offering familiarity with local courts and DMV procedures. Our law firm is located at 320 Carleton Avenue, number 4200, Central Islip, New York, 11722, United States. Contact the law firm at 631-259-6060 for a free consultation to discuss your charges and explore options for reducing or dismissing them.